It happened at 2 a.m., while most of America slept. The Supreme Court dropped a bombshell, a 6-3 ruling, 10 new rules. Every gun owner must know them now, if you carry, if you train, if you keep a firearm for protection. What changed at 2 a.m. affects you directly. This isn't speculation, this is law, and ignorance won't protect you in court. So hit that subscribe button right now, stay sharp, and let's break down all 10, one rule at a time, because what you don't know will hurt you.
Firearms Law Advisor is here to guide you. Let's dive in. Chapter 1. The Midnight Bombshell. 2 a.m. Eastern Time. The Supreme Court's website updates. A 6-3 decision goes live. No press conference, no warning, just a ruling that changes everything. The case challenged 10 specific firearm restrictions. The court sided with gun owners, but it didn't stop there. It rewrote the rules for all 50 states, from carry permits to storage laws, from purchase limits to ammunition restrictions. Every single rule now faces new scrutiny.
This decision expands on Bruin from 2022. It goes further, it goes harder, and it's already causing chaos in state capitals. The legal ground just shifted beneath us. Chapter 2. Rule number 1. Carry anywhere. The first rule changes everything about carry rights. Sensitive place restrictions just got obliterated. States love to ban guns in parks, in churches, in public buildings. The court said that's unconstitutional overreach. Unless a location has armed security, or a historical analog from the 1700s, you can't blanket ban carry there. New York's Times Square gun-free zone? Challenged. California's park carry bans? Under fire. Illinois' public transit restrictions? Being dismantled. The default is now carry allowed, not carry prohibited. This flips the entire legal framework. Gun owners just gained massive ground. Chapter 3, Rule number 2. No more lists. Gun registries just became a liability. The court ruled that mandatory registration, without historical precedent, violates the Second Amendment. States can't create databases of gun owners, not for handguns, not for long guns. California's firearm registry? Legally vulnerable now. Hawaii's permit and register system? On life support. The court cited privacy concerns and historical tradition. Registration wasn't required in 1791. It's not required now. This affects millions of gun owners. In states that demand registration before ownership, those laws may soon disappear entirely. Chapter 4. Rule number 3. Ammunition freedom. Ammo restrictions just took a direct hit. The court said ammo is protected too. You can't restrict arms without restricting ammunition. California's background checks for ammo purchases? Constitutionally questionable now. Illinois' ammo purchase permits? Same problem. States that limit bulk ammo buys? Under review. The ruling makes clear you have a right to feed your firearm without government tracking or permission slips. This opens the door to major lawsuits against states with ammo control schemes. The Second Amendment includes the bullets, not just the dun. Chapter 5. Rule number 4. Magazine bans dead. High-capacity magazine bans are collapsing. The court addressed this directly. Arbitrary limits on magazine capacity have no historical foundation. 10-round limits? Legally shaky. 15-round limits? Same issue. States like New York and Connecticut face immediate legal challenges on their mag bans. The court said limiting capacity is limiting the right itself. You can't ban standard magazines. And claim you're respecting the Second Amendment. Expect these laws to fall fast in circuit courts across the country. Chapter 6. Rule number 5. Instant approvals. Waiting periods are now on trial. The court ruled that delays,
without clear historical justification, burden the core constitutional right. California's 10-day wait being challenged. Rhode Island's 7-day hold under scrutiny. The government must prove the delay is necessary and that it existed in early American history. Most can't meet that standard. Instant background checks are fine, but arbitrary waiting periods? Not anymore. This rule alone could free up millions of lawful purchases currently stuck in limbo. The clock just became your ally. Chapter 7. Rule number 6. No more fees. Permit fees are under attack. The court hinted strongly that charging high fees for constitutional rights is essentially a poll tax, and poll taxes are illegal. States charging $300 for carry permits, that's now constitutionally suspect. Application fees, renewal fees, processing fees, all of them face legal challenges. The right to bear arms cannot be locked behind a paywall. New York, California, New Jersey all charge exorbitant permit fees. Those systems may crumble under this ruling. Chapter 8. Rule number 7. Self-defense first. The court reaffirmed the core purpose. Self-defense is the heart of the Second Amendment. Any law that undermines self-defense is presumed unconstitutional. Duty to retreat laws now questioned. Bans on defensive ammunition legally vulnerable. Storage laws that slow access under review. The court made clear, your ability to defend yourself cannot be delayed or diluted by the state. This is a massive win. For anyone who carries for protection, states must respect your right to respond immediately, effectively, without bureaucratic barriers. Chapter 9. Rule number 8. Training optional. Training requirements are crumbling. The court said training is good, but it can't be a condition for exercising a constitutional right. Maryland's 16-hour training mandate? Challenged. Hawaii's expensive certification courses? Same problem. States that require proof of training before issuing a permit now face an uphill legal battle. The government can encourage training, but it can't require it, not when the right is fundamental. This shifts the entire training debate, from mandatory to recommended. Chapter 10. Rule number 9. No discretion. Discretionary permit systems are dead. The court said no government official can decide who deserves a right. Sheriffs, police chiefs, permit boards, none of them can use personal judgment to approve or deny your application. If you meet objective criteria, you get the permit, period. This destroys may-issue systems in states like California and Hawaii. Your rights don't depend on favoritism or political connections anymore. The law is now objective, not subjective. Chapter 11, Rule number 10. Retroactive relief. The final rule is the most explosive. People convicted under now unconstitutional laws may be able to appeal and have their records cleared. If your conviction was based on a law that violates this new standard, you might have grounds for relief. This affects thousands of cases, from magazine possession charges to carry permit violations. Lawyers are already filing motions, seeking sentence reductions or expungements. This rule could free people who were punished under bad laws. The Supreme Court just rewrote the playbook. 10 new rules, 50 states affected, and this is just the beginning. More lawsuits are coming. More laws will fall. More rights will be restored. But only if you stay informed. If you believe in the Constitution. If you want to protect your rights, then you need to subscribe right now, because the next ruling could drop tomorrow. And when it does, we'll be here, breaking it down, rule by rule. Stay armed, stay educated, stay free. We'll see you in the next one.